Has expired. I call Keith Locke.
Thank you, Mr. Speaker. The Green Party is strongly opposed to this bill. In fact, it's a very sad day for New Zealand, because not only is the government moving legislation through this Parliament at the behest of a foreign multinational, Warner Brothers, which is an affront to our sovereignty, but it's completely abusing the parliamentary process. It's rushing important industrial legislation through Parliament, through all stages, in a few hours, under urgency, and denying all chance for the legal profession, for employers, for union leaders, for members of the community to make submissions on this bill. In fact, members of Parliament have only had a couple of hours to have a look at the bill and prepare their contributions. Any other bill, of course, sits on the table for 3 days, which means members of the public, including those following this debate, have a chance to figure out what the bill is before we discuss it in the House. There'll be a lot of confusion out there among people listening to this on the radio or watching it on the TV. And MPs are not being given a proper chance to scrutinise this legislation. And industrial legislation is very tricky and complicated legislation. In the Transport and Industrial Relations Select Committee this morning, we finalised a couple of bills, the Holidays Bill and the Employment Relations Amendment Bill, and these bills have been around for months, and many submissions and debates on interpretation. Quite a divisive bill in many respects, but it just showed the complexity of industrial law, and it's quite wrong to rush such law through Parliament, particularly as Jerry Brownlee, when I questioned him earlier on today, said that, Warner Brothers hasn't said it needs to go through this week. Well, why are we pushing it through this week? Either there's something, some misinformation there, or else we could have a proper select committee process on this bill. You know, what's the problem with having a proper select committee process? And the Minister of Labour says, well, it doesn't really change anything, we're just creating some certainty. I think Jerry Brownlee had a slightly different interpretation. But actually this bill produces more uncertainty in our industrial relations, because the concept behind this bill is quite different from the concept behind the rest of the Employment Relations Act. And that concept was clarified in the 2005 Supreme Court decision of Bryson versus 3'6", where it defined what an employee is. And that decision was sort of codified and explained by the screen producers organisation SPARTA. They produced a little document on what it would mean, and essentially what the Supreme Court does, what SPARTA explains, is a duck test, what you could call a duck test, that if something walks like a duck, swims like a duck, quacks like a duck, then it is a duck. And in this case, the things that SPARTA laid out were such things as the control that actors have over their work situation, where it happens, what's done, the timing of it, etc. And in reality, of course, a lot of that's under the control of the director. So in that sense, they're similar to employees. Another test SPARTA outlines is the extent to which workers, when they're going into this job, provide their own equipment, finances, take financial risks in the production, etc. And generally, actors don't do that. So there are a lot of parallels in the actual work that actors do being employees. So what this bill does is goes completely in the opposite direction from the duck test and says when the employer, the film producers and the actors sign a contract, or people in the film industry in general, then what they say in that contract, whether the actor is an independent contractor or employee, is what determines rights from there on, which is quite contrary to the general theme, as I said, of the Industrial Relations Act. And where it puts actors at a disadvantage is that now that employers know that they can not give actors under this arrangement the rights of an employee or the rights to collective bargaining, what they will say is they say, oh, you want to be an actor in our movie? Here's your contract. The contract says that you're an independent contractor and not an employee. Take it or leave it. If you don't take that, you haven't got the job on the film. So what it will mean is that these people then lose all rights to collective bargaining in relation to their employee, the film company, and that is, of course, a big problem, and it provide a feast of work for lawyers and judges in the future who will, bring back that Supreme Court decision as it applies to the Employment Relations Act as a whole and say, well, this amendment's a bit in conflict with that. Is this person an independent contractor or employee? What are their rights, etc.? It'll be a legal feast. That's why we needed to take submissions on this bill rather than just rushing it through. And there's a whole history of people being like actors, bringing their skills in labour to a situation where there's a short-term work situation, a short-term contract, a fixed contract. Many people in the construction industry, for example, they get a job on a building for a fixed period of time, paid certain amounts, and they do retain, even though they're contractors contracting for that work, they do retain rights as employees or similar to employees under the Employment Relations Act. So I think that also it's actually good for the film industry to give film workers and actors more rights. And in my experience, the more rights people have, the more confident they feel. And I think confidence is a big thing in the acting profession. If they get kicked around and denied their rights, then the work suffered, the film will suffer. So all of us here, I think every New Zealander wants the Hobbit film to be a success. This debate has never been about whether the Hobbit should be produced here or not. Everyone wanted it to be produced, directed, made here in New Zealand. But what we are saying in the Green Party is that it would be a more successful film if the rights of actors, of film workers in general, were respected and not undermined in this way. And I agree with the previous speakers that this is, sometimes over the years we've talked about banana republics and governments that have, been, and the interjection we're not even a banana republic, we're a banana constitutional monarchy. So we've got a couple of things on our hands here. But the definition of a banana republic was effectively, particularly countries in Central America who their dominant industry was bananas, and the big banana companies like at that point United Fruit in earlier times or Del Monte or whatever, they would essentially run the state because they had such a big weight in the economy. And now we see New Zealand, a developed economy, multifaceted economy, acting in the way of a banana republic. Warner Brothers comes along and says, we're not going to make this film here unless you give us more money and change your industrial laws to suit us. And bow and scrape, forget about our sovereignty, forget about our honour. Don't we have honour as a people? And just say yes sir, no sir, and then pretend it's all for the good of the workers concerned, when in fact if you study the Employment Relations Bill, it doesn't have any good spin-offs for this particular bill. Doesn't have any good spin-offs. It's in contradiction to the Employment Relations Act, and the Green Party is very opposed to it. Thank you.